The question put by this court was whether the dismissal or termination. कि अगर dismissal है जो कि प्रोबेशनर जो कि
फ्यूचर एम्प्लॉयमेंट के लिए बार नहीं
कर रहा है,
तो हमारे
He has power to recommend the termination of the services of the petitioner because termination is different from dismissal. He is continuously complaining about and this is the ground of because of this complaint only I got terminated.
all right, will. Yes.
Now the question which was put by this court,
Yes.
not in exactly in the same word, but it has been considered in four of the judgments. In the same line, when a services of a probationer is not, if the probation is not confirmed, what would be its effect? That has been considered also. The first judgment which I am relying is 2011, volume 4 SCC, page 447. It is also from a lower judiciary services,
Yes.
from a state of Jharkhand. 11/2004, 447. Para 4.
Yes.
On 28/4/2003, the zonal judge concerned referred the matter to the standing committee for further action. In terms of the decision of the zonal judge, the then Chief Justice of the High Court also referred the matter to the standing committee by way of recording an order on 1/5/2003. The matter was considered in the meeting of the standing committee held on 8/7/2003. After considering the performance and the suitability of the appellant, it was resolved that the matter be referred to the full court for consideration and decision as to whether or not the continuous service of the appellant was required. Consequently, thereupon the matter was placed before the full court meeting held on 18/7/2003, wherein it was resolved by the full court that the continuation of service of the appellant was no longer required and that he should be discharged. Consequent thereupon, the resolution of the full court was sent to the government. फिर पैरा 5 में गवर्नमेंट ने क्या किया? Now, Lordship, I am coming straight to paragraph 9. The reports placed before us disclose that at the time when the impugned order was passed, the appellant was working as a probationer munsif. A person is placed on probation so as to enable the employer to adjudge his suitability for continuation in the service and also for confirmation in service. There are various criteria for adjudging suitability of a person to hold the post on permanent basis and by way of confirmation. At that stage and during the period of probation, the action and activities of the probationer are generally under scrutiny, and on the basis of his overall performance, a decision is generally taken as to whether his services should be continued and that he should be confirmed or he should be released from service. In the present case, in the course of adjudging such suitability, it was found by the respondent that the performance of the appellant was not satisfactory and therefore he was not suitable for the job. The aforesaid decision to release him from service was taken by the respondent considering the overall performance, conduct and suitability for the job. While taking a decision in this regard, neither is any notice required to be given to the appellant, nor is required to be given any opportunity of hearing. Strictly speaking, it is not a case of removal as sought to be made out by the appellant, but was a case of simple discharge from service. It is therefore only a termination simpliciter and not removal from service on the ground of indiscipline or misconduct. While adjudging his performance, conduct and overall suitability, his performance record was as also the report from the higher authorities were called for and they were looked into before any decision was taken as to whether the officer concerned should be continued in service or not. In a recent decision of this court in Rajesh Kohli, almost a similar issue cropped up for consideration, in which this court has held that the High Court has a solemn duty to consider and appreciate the service of a judicial officer before confirming him in service, and for this not only judicial performance but also probity as to how one had conducted himself is relevant and important. It was also held in the same decision that upright and honest judicial officers are needed in district judiciary, which is the bedrock of our judicial system. Yes. The second judgment is, I am referring is the Rajesh Kohli, which has been referred in this.
Yes.
That is 2010, volume 12 SCC, page 783.
2010.
12 SCC, page 783. Kindly come to paragraph 11 of this judgment. The petitioner also submitted that his services was terminated on the ground of an alleged misconduct, namely pendency of a criminal complaint and his alleged behavior with subordinate staff, and therefore the said order of termination of service was in the nature of punishment by casting a stigma on the petitioner and therefore illegal and without jurisdiction, as no opportunity of hearing was given to the petitioner prior to passing of the order of termination. He also submitted that since he was granted increment by respondent, it is proved that respondents were satisfied with his service and therefore the order terminating service is without jurisdiction. In this present case also, the petitioner has alleged that her services has been terminated on the ground of misconduct. Therefore, the requirement is necessary. Now, this has been answered in paragraph 21 onwards. I'm sorry, paragraph 18 onwards. The consideration and answer. Paragraph 18. During the period of probation, an employee remains under watch and the service of his conduct is under scrutiny. Around the time of completion of the probationary period, an assessment is made of his work and conduct during the period of probation, and on such assessment a decision is taken as to whether or not his service is satisfactory and also whether or not on the basis of his service and track record his service should be confirmed or extended for future scrutiny of his service, if such extension is permissible, or whether his service should be dispensed with and terminated. The services rendered by a judicial officer during probation are assessed not solely on the basis of judicial performance but also on the probity as to how one has conducted himself. The aforesaid resolution taken by the full court on its administrative side clearly indicate that the matter regarding his confirmation or otherwise or extension of his probation period for another 1 year was considered by the full court, but since his service was not found to be satisfactory on consideration of the record, therefore the full court decided not to confirm his service and to dispense with his service and accordingly recommended for dispensation of his service. On the basis of the aforesaid recommendation of the High Court, an order was passed by the government of Jammu and Kashmir dispensing with the services of the petitioner. These facts clearly prove and establish that the order of termination of service of the petitioner was not issued by the Jammu and Kashmir High Court, but it only recommended his termination as his service was not found to be satisfactory. The aforesaid recommendation was accepted by the government, which finally ordered the termination of his service. The aforesaid order was an order of the competent authority and issued by the government of Jammu and Kashmir. Since the order was issued by the competent authority, it was valid order and should be treated as such, although it was specifically not issued in the name of governor. In the present case, two orders are challenged. One, which was the order of the High Court based on the basis of resolution of full court.
Bharat, please tell me this, whether the termination, the question put by this court was whether the dismissal or termination.
That has been, that on the last date of hearing,
Yes.
that has been answered in 2020, volume 18 SCC,
71.
page 71. That has been answered in that. Now, here all the cases between these two cases are probational.
Yes.
The cases in which there is a probation, it is the right of the employer to continue with the probation or to dispense with the service.
No more.
I am developing.
Yes.
I am developing.
My question is see, competency of the standing committee is in question. Whether she is making a stand.
Yes. I am coming.
Yes.
The competency of the standing committee is raised on the ground that since it is a removal, now the standing committee has the power to pass any orders except the order of dismissal.
So that's why whether the termination, whether the probation.
A specific word has been used, dismissal, other than dismissal. Other than dismissal. Now the full standing committee has not passed any order with respect to dismissal. It has passed an order with respect to termination or not confirming the employee. Now non-confirmation of employee would fall under the definition of termination, simpliciter, in view of this judgment.
So please tell me whether the dismissal, if it is a dismissal, then the standing committee has no jurisdiction.
Standing committee has no, as per rule, standing committee would not have the jurisdiction.
Yes. So when you are discontinuing the probationer, whether it will fall within the ambit of dismissal or termination.
It would fall under the definition of termination because she has not been precluded to join any other services. If it is an order of dismissal or discharge, may amount to
dismissal has
that.
been defined under the which rules? Whether it has been defined in civil services rules?
In civil services rules also, Lord Lordship, there is a provision which says that termination of a probationer would not amount to a penalty.
रूल 10 निकालना तो सिविल सर्विसेज
CCA rules में CCA rules निकालना।
मेजर पेनल्टी की परिभाषा में देखना रूल
मैं निकाल के दे देता हूँ, देना बाबू।
देखिए तो दे दीजिए।
That is Lordship Rule 10.
डिफाइन दी रूल्स है हिंदी में पढ़ो, हिंदी में दे दो।
हाँ, इसका जो एक्सप्लेनेशन का 8 का
वो तो डिग्री लॉट है ना, दोनों हिंदी अंग्रेजी दोनों है।
अच्छा,
आजू बाजू है।
नहीं आजू बाजू नहीं है, ये शायद हिंदी का ही है।
अरे
नहीं, रूल 10 का 8 इस पर एक्सप्लेनेशन 8 स्मॉल ए।
हाँ
Rule 10. It defines the penalties.
हाँ
Now, Lordship, kindly come to explanation.
नहीं है ना, इंग्लिश है ना।
Explanation.
हाँ
Rule 10. The following penalties may, for good and sufficient reason and as hereinafter provided, be imposed on a government servant.
हाँ
Major and minor and major penalty. Now, there is an explanation.
यस
The following shall not amount to penalty within the meaning of this rule, namely. Now, Lordship, kindly come to 8.
हाँ
Termination of services of a government servant appointed on probation during or at the end of period of his probation in accordance with the term of his appointment or the rules and orders governing such probation. So, it would not amount to any penalty because the petitioner herein, he was a probationer.
यस
In view of Rule 10, Explanation 8, it would not amount.
नहीं। अच्छा, अब हमको ये जजमेंट बताइए कि अगर डिस्मिसल है जो कि प्रोफेशनल जो कि आप
फ्यूचर एम्प्लॉयमेंट के लिए बाहर नहीं
कर रहा
तो
है।
हमारे डिपार्टमेंट में ही हुआ है। देयर वाज ए प्रोबेशनर हु सर्विसेज वर terminated. She appeared in the next examination and she cleared and now she is civil judge class 2. क्या नाम क्या उसका? श्रीवास्तव। आकाश श्रीवास्तव।
तो नहीं, अब इसमें कोई लॉ बताइए कि टर्मिनेशन का थी। यू हैव टू मेक आउट अ केस दैट द स्टैंडिंग कमेटी हैज जुडिक्शन।
Standing committee has the jurisdiction to pass all orders except the order of dismissal.
So dismissal.
Now, since her case does not fall within the category of dismissal,
you are trying to distinguish your case. That is not a. It's a case of a termination simpliciter, and dismissal means
something attached. Something attached.
Please tell us. What do you mean by whether the word dismissal and what will be its consequence will have been come up for consideration before the Honorable Supreme Court?
That has been considered in that 2020 judgment.
This 71.
Page 17. Manadi forfeit.
Manadi. What is whether dismissal has been considered?
After referring lots of judgment, Paragraph 34 onwards.
हाँ पढ़िए तो जरा
The expression 2020
वॉल्यूम 18
volume 18 page 71. इसका पैराग्राफ 34 देखेंगे,
यस
which is at page number 117.
पेज 34
Yes, para 34. The expression used in section 4.1, termination does not include dismissal. The Constitution Bench considered the difference between termination and dismissal in M. Ramnath Pillai versus State of Kerala, wherein the following observations were made as to distinction between the terms of dismissal and termination, considering the provisions of Article 311 of the Constitution. It was observed, when Article 311 states that no person shall be dismissed, removed or reduced in rank until he has been given a reasonable opportunity of showing cause against the action proposed to be taken in regard to him, it affords a protection and security of government service. Article 311 applies to all government servants holding the permanent, temporary or officiating post. The protection afforded by Article 311 is however limited to imposition of three major penalties. These are dismissed, removed or reduction in rank. The word dismissed, removed or reduction in rank are technical words. Both in the case of removal or dismissal, there is a stigma. It also involves loss of benefit.
पैराग्राफ 34.3 पढ़िए तो
जी
34.3
34.3 34.2 में भी है
यस
34.2. Similarly, in Balkottaiah versus Union of India, the provision of Article 311 came up for consideration. The distinction between dismissal and termination was discussed thus. It is then contended that the procedure prescribed by the security rules for hearing of the charge does not satisfy the requirement of Article 311 and they are in consequence void. But Article 311 has application only when there is an order of dismissal or removal, and the question is whether an order terminating the service of the employee under Rule 3 can be said to be an order dismissing or removing them. Now this court has held in series of decisions that it is not every termination of service of an employee that falls within the operation of Article 311, and that it is only when the order is by way of punishment that it is one of dismissal or removal under that article. फिर जजमेंट रेफर कर दिया.
then 34.3
फिर उसी में आगे बोला, it was therein held that if a person had a right to continue in office either under the service rule or under
no that's why I asking you please read it paragraph 34.3
Yeah. In Shyamlal versus State of UP, it was held that every termination is not dismissal or removal. In Ravindra Kumar Mishra versus UP State Handloom Corporation, the distinction between termination, simpliciter and punitive dismissal was considered, and it was observed. As we have already observed that though the provision of Article 311(2) of the Constitution do not apply, the service rules, which are almost on a par, make the decision of this court relevant in disposing of the present appeal. In several authoritative pronouncement of this court, the concept of motive and foundation has been brought in for finding out the effect of the order of termination. If the delinquency of the officer in temporary service is taken as operating motive in terminating the service, the order is not considered as punitive, while if the order of termination is founded upon it, the termination is considered to be punitive action. This is so on account of the fact that it is necessary for every employer to assess the service of the temporary incumbent in order to find out as to whether he should be confirmed in his appointment or his services should be terminated. It may also be necessary to find out whether the officer should be tried for some more time on temporary basis, since both in regard to a temporary employee or an officiating employee in a higher post, such an assessment would be necessarily merely because the appropriate authority proceeds to make an assessment and leaves a record of its view, and same would not be available to be utilized to make the order of termination following such assessment punitive in character. In a large democracy as ours, administration is bound to be impersonal and regard to the public officer, whether in government or public corporation. Assessments have to be given, has to be in writing for the purpose of record. We do not think that there is any justification in the contention of appellant that once such an assessment is recorded, the order of termination made soon thereafter must take the punitive character.
Now, in paragraph 34.4, the Honorable Supreme Court has considered the 7 judges bench, Samir Singh versus State of Punjab, arising out of a probationer judicial officer, where this court has considered with the termination of a probationary judicial officer on the basis of vigilance inquiry, which was conducted by the state government. The court held that termination to be bad, and while doing so, they laid down the law in that the behalf.
वो पुरुषोत्तम लाल ढींगरा को 7 जजेस बेंच ने कंसीडर किया था और उसको उन्होंने अफर्म किया।
नहीं, उसके बाद सबसे वाला जो है पैराग्राफ 34.4 में पढ़िए ना।
हाँ, पैराग्राफ 34.4 में उन्होंने पुरुषोत्तम लाल ढींगरा को कंसीडर किया और उसको अपील किया।
नहीं, उसके नीचे में देखिए, दी 7 जजेस ऑफ सबसे सिंह 1974 टू 60
पैरा 27।
यस, उसमें 7 जजेस का जजमेंट है विद
ये विशाखो मिश्रा में कंसीडर हुआ
विद रिगार्ड टू दी प्रोबेशनर जुडिशियल ऑफिसर।
These judgments have been followed by a bench of 7 judges in Shamsher Singh, wherein this court was considered with
अच्छा, तो आपके पास ये बताइए, अगर प्रोबेशनर जुडिशियल ऑफिसर का परफॉर्मेंस आपने कैसे अप्राइज किया?
वो मैंने आपको कल उस दिन दिया था।
हाँ, वो वापस दीजिएगा हमको, वो रिकॉर्ड वापस दीजिएगा।
ये पहले इन लोगों का सबका एक्सटेंड 10 ऑफिसर्स थे, इनका सबका एक्सटेंड किया गया। उस एक्सटेंशन के बाद फिर उनको रिकंसीडर किया। उस रिकंसीडर में 9 लोगों को के लिए कहा कि इनको कंफर्म कर सकते हैं, उनको कंफर्म किया गया। एक के लिए कहा कि इनको कंफर्म नहीं करना है।
क्या आपके दिमाग में ये जो पुरानी इंक्वायरी रिपोर्ट और ये थी, देखिए, फाउंडेशन वाज दी इंक्वायरी कंडक्टेड बाय 2 or 3 जुडिशियल ऑफिसर्स।
नहीं, वो तो सारी इंक्वायरी क्लोज डाउन हो गई।
नहीं, क्लोज डाउन हुई है।
नहीं, that was not taken into consideration. What was taken? I got my lord's point.
Yes.
What was taken into consideration? Her service record and the complaints received against her.
When you proceed on the complaint
And
made
on
by
those
the
complaints, explanation was sought from her. A complaint.
so this complaint was foundation.
No, it was not a foundation.
Then why you have taken into consideration?
They-
Why you have called for
Because the entire record of all the probationers was kept before the standing committee of all the probationers.
Yes.
Not only her, all the probationers.
Yes.
So far as the other probationers are concerned, there was no such there was no such complaint. So far her is concerned, there were 5 complaints and a serious complaint. She had written a judgment in order sheet. She had said that the judgment is pronounced. There was no judgment in the record. An explanation was sought. She said कि वो छुट्टियां लगी थी इसलिए मैं नहीं कर पाई। 10 दिन के बाद भी वो जजमेंट रिकॉर्ड पे नहीं आया। तो इट वॉज ए सीरियस कंप्लेंट कि आपने तो बोल दिया कि जजमेंट हो गया, जजमेंट है कहां? और जो इनके रिपोर्टिंग अथॉरिटी हैं उनके कमेंट्स हैं कि शी इज नॉट रेडी टू इंप्रूव हरसेल्फ। प्रोबेशन का मतलब क्या? प्रोबेशन का मतलब यह है कि वी हैव टू असेस द कैंडिडेट वेदर ही और शी इज फिट फॉर द जॉब और नॉट। द प्रोबेशन पीरियड ऑफ 2 years was given to them, all of them. After 2 years, a general assessment of all the persons were taken into consideration. Out of all the persons who were appointed on probation, we found that 10 of the officers are not suitable at this stage. So we extended the probation of all the 10 judicial officers. Remaining, whose assessment was good, they were already confirmed. These 10 probationer officers, these 10 officers were again, probation was extended. After the end of that probation, again assessment was made, and it was found that in this extended period, these officers had improved their conduct. These officers had improved their way of judgment writing. There is reporting authorities say that she does not have the capacity to write the judgment. And what the Supreme Court says in this Jammu Kashmir case, that even if it is taken into consideration, even if the complaint is taken into consideration, that would not give a right to the High Court to interfere, right to the High Court in a judicial review. Because it is a simpliciter termination of a probationer. Because if the probationer is not confirmed, what would be the effect? The effect is that the person would not be continued in service by whatever nomenclature it has been discussed. Here in this case, it is a plain case of simpliciter termination in view of the fact that even after extension of probation period, the performance of the judicial officer was not up to the mark. That was the sole basis.
That's all.
Yeah.
Yes, madam.
ये रिकॉर्ड्स आप
दे दीजिए।
वो मैं फ्लैग कर दूं इनका अलग से या सब पूरा दे दूं?
ये पढ़ लीजिए।
पूरा दे दूं।
Yes, madam.
Yes, Your
By
Lordship.
way of reply.
Yes, Your Lordship.
Pencil.
Yes, Lordship, Your Lordship. The learned counsel has argued according to Rule 4C9 of the High Court of Chhattisgarh Rule 2007, the standing committee has power to recommend the termination of the services of the petitioner because termination is different from dismissal. Here clearly said that, but when we go through the bare reading of this rules,
है रूल है यस हाँ रूल
this committee is the standing committee is made under Rule 2 sub-rule S. Standing committee means the committee constituted under these rules. And High Court is defined under Rule 2F. Court means High Court of Chhattisgarh, and this is defined under Article 216 of the Constitution. Here, the power of the standing committee is deal with in Rule 4C, where there are powers to recommend, which is specifically mentioned in sub-rule 2, to make a recommendation for promotion of subordinate judges to the rank of ADJs and the additional district judges and section judges to the rank of district judges and their initial and their posting on promotion appointment. Then fourth, to make recommendation. Fifth, again deals with to pass order. Sixth, deals with to pass order. Seven, deal with to make a recommendation for the deputation of lower judicial services or higher judicial services to post under Government of India, Government of Chhattisgarh or other state government or to foreign services. And then when we come to Rule 9, it says to pass order of suspension, initiation of departmental proceeding against member of the higher judicial service and subordinate judicial service and consequential order in the said proceedings other than that of dismissal from service. Here it is clear written that to pass order, and recommendation is different from passing an order, because when authority in or committee passes an order, it means it is a complete authority to pass that to do that thing. And when we go to the service rule, where I was appointed, in which section Rule 11,
yes.
Rule 11 sub rule 2 says that the High Court may at any time before the completion of probation period extend the period of, Rule 4. The High Court may at any time before the completion of period of probation recommend termination. Here it is clearly mentioned that the recommendation should be made by the High Court. Here the learned counsel has recently stated two judgments, referred to judgments, this judgment of the state of Jharkhand and this Rajesh Kohli judgment, state of Jammu and Kashmir. In both cases, he himself read that recommendation was made by the standing committee, and that was the place before the full court committee, full court of the High Court, and then it went to the state government, and then the order of termination was passed. So he himself recently he read this thing that the recommendation is made by the High Court, not by the standing committee, in this Jharkhand case only. And thereafter, thereafter, the learned counsel has stated in his argument that the deciding the confirmation of all 10 judges, including the petitioner, the ACR, complaints, conduct comments by the reporting authority were taken into consideration. Here I first deal with the ACRs. The learned counsel stated that ACR for the year 2014-15 was taken into consideration. But in the reply filed by the High Court, kindly see the page numbers 403. 402, the para 20, in the last fourth line.
Yes.
It was written by them that the petitioner was awarded grade D, that is average for the year 2014 and 2016-17. And adverse remarks were recorded in the ACR. As many as 5 complaints were made to the district judge Ambikapur by Ms. Anju Gupta, ADPO, R.S. Shukla. He wrote about 2 ACRs, 2014 and then 16-17. And a document is also filed by the High Court in page number 410, where this is the, I think, placed before the standing committee. This document was also placed. Here, they specifically written entries in the confidential reports for the last 3 years. Here they report year 2013-14, it was not recorded. 2014-15, D was awarded. And here they written 15-16, D. It means they referred this ACR also.
So you want to say that for recording their satisfaction that your probation should not be considered extended, they have taken into consideration your ACRs.
Yes, yes, my
मैं
lord.
इसको क्लेरिफाई कर दूं, थोड़ा सा कंफ्यूजन इनको भी है. अगर पेज नंबर 410 देख लें,
हाँ,
देख लें.
yes, बताइए.
शायद इसके बेसिस पे आर्गुमेंट बिल्डअप करना चाह रही हैं.
हाँ हाँ.
पेपर बुक का 410.
अच्छा. हाँ.
इसमें 13-14 ACR नॉट रिकॉर्डेड. 14-15 D एडवर्स रिमार्क एज पर अनेक्चर ए नीचे लगा हुआ है. फिर 15-16 D ग्रेड एंड रिमार्क इफ एनी येट टू बी कम्युनिकेटेड. सो 15-16 तो कम्युनिकेट ही नहीं हुआ, तो कंसीडर हो ही नहीं सकता. और 14-15 कम्युनिकेट हुआ है और जो इनके रिमार्क्स हैं उसके नीचे लिखे हैं बाय द डिस्ट्रिक्ट जज. नॉलेज ऑफ स्फीयर ऑफ वर्क, द ऑफिसर्स बेसिक नॉलेज ऑफ लॉ एंड इंस्ट्रक्शन रिलेटेड to her function is average. Management quality, her management qualities mentioned in this point are average. Communication skill, written and oral, the officer communication skill both in written and oral is average. She is required to improve her ability to put her views and arguments both in written and oral. Appraising ability, the officer's skill and capacity regarding evaluation and recording performance of subordinate is an impartial and objective manner is average. So what was taken into consideration is 14-15 and the remarks. 15-16 का तो कम्युनिकेट ही नहीं हुआ. लॉ इज वेल सेटल की अगर ACR कम्युनिकेट नहीं किया तो आप तो उसको कंसीडर कर ही नहीं सकते.
Your Lordship, these remarks were advisory remarks. These were not the adverse remarks. But kindly see this 15-16 remarks. First, I wanted to go through the letter, but page number 249, annexure P9. Kindly see the actual what they have remarked in my 2015-16 ACR.
Yes.
Nature and quality of work. Please comment on the para 2 as filled out by the officer. As per work done chart provided by the officers, he has disposed of very less number of contested. Eventually, the officer has no ability to control the staff. Not only staff posted in her court, but also the ADPOs, advocates, police have complained orally many times and even in writing regarding her attitude and behavior. It is also mentionable that even the ladies ADPOs are not interested to work in her court. Quality of output, the officer's quality of performance having regard to standard of work comes to average category 6.24 unit per day. For norms fixed by the Honorable High Court. It has also been found that she has claimed units in those uncontested cases regarding which no unit has been prescribed by the Honorable High Court. Unless she will not take in interest to her work, she would not overcome from her constraint. Knowledge of sphere of work, the officer's level of knowledge of function-related instructions is average. Leadership quality, the officer's capacity to achieve target is not up to the mark until and unless she will not change her attitude, behavior, she would not be capable to achieve the
Yes,
target.
madam, you have already argued that point on like this. Now, please tell us what is the additional rejoinder you want to make submission.
Just few minutes I will take the comment by the honorable portfolio in this
Yes.
this ACR. The complaints are alarming. The nature of bulk of complaints about behavior and judicial orders are not at all satisfactory. As appears, she do not hesitate to claim charges over on superiors subject to do. And then he lastly pointed out she would not be able to discharge any other job. This comment is made by the honorable portfolio judge that she is not able to discharge any other job. Any other job. This remark has been done, and this ACR was not communicated to me within a reasonable time. Here there is a regulation.
This pertains to the period, which period?
14, 15,
15,
16.
16, which were not taken into consideration.
This were not communicated. Despite of a regulation, Regulation 7, 2007, there is a regulation regarding confidential rules where Note 7, Regulation 7, note says that it should be communicated on or before 1st of August.
Which page you are reading? Which page?
She is reading page number 249 and 250, which was neither communicated to her and neither taken into consideration. This is our specific case.
Yes, this specific stand you have taken.
Page 249 and 250.
250.
P17.
Yes.
But Your Lordship, when we go through the regulations, Chhattisgarh Judicial Officers Confidential Rules Regulation 2015. Here, Regulation 7, preparation of ACR, in which note, it says every endeavor shall be made by the authorities in early finalization of confidential report so as to enable the authority of communicate the final conclude confidential report to the member of service on or before the 1st of August.
All right.
So why it was not communicated to me in 2016 only? And there is a specific guideline in Devdutt case. The Supreme Court has issued the guideline to communicate so that they can improve their work.
All right. This is all. So,
There are some more submission, my lord.
all right.
Your Lordship, kindly see page number 227. Here I have attached one notification by the state government where it says, अतः पुनः निर्देशित किया जाता है कि सेवा संबंधी मामलों में अनुचित जाति, अनुसूचित जनजाति, अन्य पिछड़ा वर्ग के अधिकारियों कर्मचारियों की गलती किए जाने पर भी सर्वप्रथम समझाई किया जाकर उनकी कार्य पद्धति में सुधार लाने का प्रयास किए जाए। तत्पश्चात भी यदि सुधार नहीं होता तो उन्हें चेतावनी दिए जाए। इनके विरुद्ध अनुशासनात्मक कार्यवाही, गोपनीय प्रतिवेदनों में प्रतिकूल टिप्पणियां कोई ठोस आधार हो तो ही पूर्ण विचारोपरांत की जाए। इन निर्देशों के उल्लंघन के मामले शासन या वरिष्ठ अधिकारियों के ध्यान में आने पर दोषी अधिकारियों के विरुद्ध अनुशासनात्मक कार्यवाही की जाए। पेज नंबर 227. This is Annexure P14.
Yes.
Regarding the non-communication of ACR, the Honorable Supreme Court in Abhajan,
Yes, that is clear. Devi Datta and everything is clear. Yes.
this will violate of Article 14 also.
Yes, yes. That is all.
Okay. Thank you, my lordship. Here, the contention is that I got average. My work done was average, below average during the for the period 2014 to 15.
Yes.
With the kind permission, I want to submit that regarding 11 Rule 11. Sub-rule 2 of this service rule, it says a person appointed to a post in category such and such shall undergo a judicial training for a period of 1 year. In accordance with the, here it is clearly mentioned that I went through a training for a whole 1 year. I joined in December 2013, 27 December 2013, and then for the whole year of 2014, I was under training. And the last training ended on 11th December 2014. That is also attached in this file. That is Annexure P6, page number 71, 72. And on 31st January 2015, I got JMFC power. So I just worked for 2-3 months. So working for only 2-3 months, and the work done is calculated out of 220 working days. So how it could be possible to get good or very good criteria in my work performance. And this was not only the case of mine, but all 34 judges who were appointed at that time, all have got, I must say that all have this average work done performance in that ACR for the year 2014 and 15. And here, another thing is pointed out by this learned counsel is that ACR for 2014 and 15, I was the only one, and one another judicial officer, she also got D. Rest of other did not got D. So here, because of my information I got through all judicial officer at that time, I came to know that all officers who got D during for this ACR for 2014 and 15, their provision was only extended. So that can be when Honorable High Court can go through the records and find out the truth that all the 10 officers were in ACR for 2014-15, they got D. This is the reason our probation period was extended. Now, the submission by the learned counsel is that overall performance was taken into consideration. But then also he only pointed out that 2014 and 15 ACR. What about 15-16? What about my work done? I got transfer in May 2016 to Kanker, and what was their work performance? All these were not considered. That is also attached in my file.
All right.
So, and then, yes, Your Lordship.
Yes.
And about the comment, complaint, learned counsel.
You are repeating, madam. You already made a submission on the when you were given an opportunity to make submission.
Because this complaint is comment by the reporting authority. This is not complaint by an individual. That's why I just wanted to point out. You can
whether the complaint, the comment made by the reporting authority has been taken into consideration. No.
But
if it has not been taken into consideration, then see.
Okay, Your Lordship.
I think you have argued at length very well.
Yes, that I mentioned in my synopsis
clarification मैं
also.
कर दूंगा.
Yes.
इन्होंने पेज नंबर
One more thing, one last
Yes,
thing.
please
go on.
Yes.
Conduct, about the conduct. I have two reporting authorities during my service tenure of 3 years. One is District Judge Ambikapur and another District Judge Kanker. While I got transferred to Kanker, there were no complaint in regarding my judicial work or conduct by the reporting authority or anyone from the this Kanker district. So this is my submission. And one more thing is that while we go through this complaint, one more thing, ADPO Anju Gupta, she in her reply, when I complained about her, in reply in page number 377, she clearly stated that विश्वसनीय सूत्रों से पता चला है कि आकांक्षा भारद्वाज की बहुत सी शिकायत जिला एवं सत्र न्यायाधीश अंबिकापुर द्वारा माननीय उच्च न्यायालय छत्तीसगढ़ बिलासपुर भेजे गए हैं. He also points out that my reporting author is continuously complaining about and this is the ground of because of this complaint only I got terminated.
All right, we'll see.
एक clarification है. She had referred page number 249. For a
Yes.
moment.
Yes.
249 date.
214. 249. Yes.
It is dated 10/4/2017.
Yes. After the
termination.
That's all. Argument, madam, written synopsis दे दीजिएगा. You may file written synopsis also.
About this, I have
Everything.
already filed written synopsis.
Even if you want to say something more, you can give it in your writing. In your synopsis, there is no difficulty.
Okay, thank you.
Mr. Bharat, you also. Argument heard, reserved for judgment. The parties are directed to file written synopsis within 15 days.
Within?
Within 15 days.